Good morning. Are we ready to proceed?
Good morning, Your Honor. Yes, the state's ready to proceed.
Good morning, Your Honor. Yes, we're ready at the jail.
Thank you. Good morning. We're here today for the weekend in custody arraignment calendar. Today is Sunday, November 30th. Are there any special requests or requests regarding the order of today's proceedings? I do know that we will do Mr. DeMars first.
Your Honor, the state has no special requests this morning.
And neither do we at the jail, Your Honor.
Thank you. First, we'll have Andrew DeMars, followed by Shaylin Soto. Good morning. We're here today for a bail hearing. We've previously been here for probable cause determination and and with the discussion of probable cause had been determined. Public Defender's Office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 10 or a higher risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So, Your Honor, the named victim, I believe, is present this morning. I believe she just intends to watch. I'm not sure whether she wishes to give a statement to the court. She told my office that she doesn't want a no contact order because she wants to be able to communicate with the defendant about the baby. So the state's requesting bail in the amount of $20,000, DAS supervision with testing for controlled substances if he's able to post. As Your Honor noted, he scores a 10 on the risk assessment. In 2024, he's got a misdemeanor conviction for possession of drug paraphernalia. He had an FTA in that case, a misdemeanor arrest for trespassing. That case was ultimately dismissed, but he did also have an FTA, a pretrial FTA in that case as well. 2022, he's got a felony conviction for attempted transport of a controlled substance. He was sentenced to 12 to 36 months prison in that case. His 2022 PSI lists 2 prior felony convictions, 1 prior gross misdemeanor conviction, and 34 prior misdemeanor convictions. The highlights are a 2021 gross misdemeanor conviction for conspiracy to possess stun gun by a prohibited person. In that case, he did have a failure to appear pretrial and 2 arrests while on probation. He was ultimately removed from specialty court and his probation was revoked. Also in 2021, a misdemeanor conviction for possession of drug paraphernalia. In that case, his supervised bail was revoked twice. 2010, he's got a felony conviction for sales of a controlled substance and a felony conviction for burglary. And notably, Your Honor, he's failed to appear around 15 times since 2015. So he's a very high risk of future non-appearance as well as continued criminal conduct. So the state is requesting bail in the amount of $20,000, DAS with testing for controlled substances if he's able to post.
Thank you. And just to confirm, State, did you have discussion with the named victim as to whether or not she wanted a no contact order indicating just no in-person contact based off of that?
So Your Honor, she didn't indicate whether I'm not sure whether we asked that specific question though. Unfortunately, I'm sorry about that.
Thank you. Defense?
Thank you, Your Honor. And speaking with Mr. DeMars this morning, he is indicating that he received services through the Life Change Center and that treatment experience has been a key to helping him to get on track. It's been a life changer. With that structure and support, he goes very regularly, is subject to testing and receives his medication assisted treatment there. That improves his ability to manage his personal affairs and attend to future court dates. Understanding he has really struggled in the past, but again, for him, being connected with that program has made a difference for him and will continue to make a difference for him in handling his court obligations. He is currently unhoused, but he would stay at the shelter where there is additional structure and support for him to have a way to stay warm and again, provide structure to attend to his court appearances. So, Your Honor, he does not have the financial means to post any money bail with any supervision conditions that this court deems appropriate. We are requesting an own recognizance release. And one's idea would be to increase the drug testing. He is getting tested at Life Change Center, but would benefit from just additional structure and supervision, imposing that and showing proof that he is engaged at the Life Change Center would further be a condition that would be less restrictive for this court to adopt this morning.
Thank you. Ms. Howard, the law affords you an opportunity to be heard. You do not have to speak if you do not wish to. If you do wish to speak, I'm just going to have you unmute your microphone and turn on your camera. Thank you. The court does not see that either has been done, so the court will go ahead and proceed. Thank you for being present here, Ms. Howard. Based off of the information provided, the court does find that in the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and the named victim in this case. The court will note the lack of ties as indicated in the NPRA, the substance use history, the history of failure to appear, the compliance concerns as outlined, and it will assess bail in the amount of $5,000 that will be bondable. And Ms. Phillips, can you confirm based off of the charge whether or not this qualifies for the 10% option?
So let me just check really quickly, Your Honor, but I don't believe there are any Category B felonies. There are not. So under the court's administrative order, the 10% option is available.
Thank you. I just wanted to confirm that. So there will be a 10% cash option for this based off of the information. I do find that is appropriate. Given the request of the named victim, I will not be imposing a no contact order at this time, just to make sure that is very clear. But sir, I will require that you be supervised by the Department of Alternative Sentencing. So you must check in with the DAS, the Department of Alternative Sentencing, within 24 hours of release. You will be required to be subjected to random drug and alcohol testing through the Department of Alternative Sentencing. So you cannot use any controlled substances or alcohol or medication unless you have a valid prescription. I am also ordering that you comply and show proof of compliance in the engagement with Life Change Center. And just to confirm, defense, that is Life Change Center, correct?
Yeah, Life Change Center.
Yes, that's correct, Your Honor.
Thank you. So you must provide them with continuing proof of engagement in that treatment. I do find that is necessary in order to ensure the safety of the community and compliance with court orders. However, that alone is not a least restrictive means. That will be the order of the court, and we'll go ahead and set a 72-hour hearing, and that will be set for December 5th at 9:30 a.m. Thank you.
Contact with DS in 24 hours being released. So
Release?
nope.
Jalen Soto first, and followed by Raul Avina Jr. And thank you, Ms. Howard, for being present.
I'll do the best to get out.
Good morning. We're here today for a bail hearing. Probable cause had previously been determined. The public defender's office had been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 2 or low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor, the state's not objecting to an own recognizance release from Ms. Soto with DAS supervision and no contact with the victim, Alexa Salazar, or her residence at 1730 Stratford Drive.
Thank you. Defense?
Your Honor, we would have no objection to that. We will confirm an alternative residence. We had information that our client resided at that address, but she has.
Would you mind confirming with your client of the information? I'll just note in the probable cause declaration has conflicting information regarding the residences.
Your Honor, just confirming that the 1730 Stratford Drive address belongs to Ms. Soto, that the alleged victim lives in an apartment complex that's not too far from that location, but does not live in that residence.
Thank you. The court will go ahead and grant an own recognizance release. And ma'am, I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community. I'm not imposing supervision with the Department of Alternative Sentencing. Sir, ma'am, you are ordered to check in with the Reno Justice Court to confirm your contact information within 1 business day of release. So that means that you must go to Reno Justice Court on Monday. Additionally, I am going to include that you are to have no contact with the named victim in this case of Alexa Salazar and her residence. We'll just note that. So Ms. Phelps, if you have that information that you can provide, then we can go ahead and add that in. However, at this time, it'll just say and her residence. That will be the order of the court, and we will set an arraignment, which will be set for December 18th at 9 a.m. So you must appear in Reno Justice Court on that date and time. Thank you. Raul Avina Jr., followed by Andres Corralo Solario.
Well, it can take some hours, but yes.
Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 6, which was overridden to a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's requesting bail in the amount of $5,000, DAS supervision with testing for controlled substances if he posts, and no contact with JCPenney. So the score of a 6 was they did override it due to a history of failing to handle court matters. 2023, he's got misdemeanor convictions for resisting and possession of drug paraphernalia. He's got a felony arrest for failing to appear, a gross misdemeanor conviction for attempted possession of a stolen motor vehicle. In that case, Judge Draculich sentenced him to 180 days in the Washoe County Jail because she found him to be unsupervisable after numerous pretrial violations and numerous pretrial failures to appear. Per his 2023 PSI, he had 19 prior misdemeanor convictions at that time, and I counted 9 failure to appear warrants throughout his history. So he is a very high risk of future non-appearance and continued criminal conduct. So the state is requesting bail in the amount of $5,000, DAS supervision with testing for controlled substances if he's able to post, and no contact with JCPenney.
Thank you, defense.
Thank you, Your Honor. We certainly have no objection to no contact with JCPenney. In addition, Mr. Avina has no financial resources to post any amount of money bail. We were able to speak with his father to confirm his residence and that he is welcome back to that location. He's been staying with his father. We were also able to verify his phone number. He did receive a point for the phone number not being verified when pretrial completed the MPRA. Understanding that there's still an override, it would bring him to a 5. He has not been employed, but again is staying with his father. And there appears to be controlled substances as a concern. So a less restrictive option for this court, rather than money bail, would be to order him to have supervision and testing as determined by the supervising agency. With that, would submit.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment with the reduced score as discussed by the defense and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the appearance of the defendant as well as the safety of the community. The court will note the significant history regarding failure to handle court matters, as well as the history of failure to appear. Bail will be set in the amount of $5,000 that will be bondable with a 10% cash option. If the defendant is able to post that bail amount, sir, you will be required to be supervised by the Department of Alternative Sentencing. So you must check in with the DAS within 24 hours of release. You will be required to have no contact with JCPenney, so you must stay 100 feet away from that location. Additionally, you are required to not use any controlled substances or alcohol, including marijuana, and be subjected to random drug and alcohol testing. I do find that there's a sufficient nexus to require that based off the allegations as well as the criminal history discussed. That will be the order of the court, and we will go ahead and set a 72-hour hearing, which will be set for December 5th at 9:30 a.m. Thank you.
Says you're gonna make contact.
Andres Corralo Solario, followed by Lawrence McDavis.
Morning, Your
Good
Honor.
morning. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 6 or moderate risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's requesting bail in the amount of $10,000 with DAS supervision if he's able to post. So he scored So he was scored 0 points for pending case. He does have a pending battery with a deadly weapon. It looks like though he was booked on that. It was an original warrant, I believe, and he was booked on that at the same time. So perhaps that's why he wasn't scored. So he's in custody on that pending battery with a deadly weapon, and he was also booked on a contempt warrant out of Sparks Justice Court. Um, let's see. In addition to that battery with a deadly, this year he's got a gross misdemeanor arrest for indecent exposure out of Lyon County with no disposition. He's got a misdemeanor conviction this year for destruction of property. In that case, his own recognizance release was revoked for pretrial violations, and then a contempt warrant issued for failure to comply with the Obey All Laws clause. I believe that was out of Sparks. The warrant issued when the battery with the deadly weapon warrant issued. 2019, he's got a felony conviction for conspiracy to commit robbery. In that case, he had pretrial violations and a pretrial failure to appear warrant. His probation was temporarily revoked twice, and then he was dishonorably discharged from probation in 2023. Per his 2019 PSI, he had at that time 8 prior misdemeanor convictions with 3 failure to appear warrants. So he's got a horrible history of compliance while on pretrial supervision with, it looks like every case he's been released on, he's had violations in addition to failures to appear. So he's a high risk of future non-appearance as well as continued criminal conduct. The state's requesting bail in the amount of $10,000 with DAS supervision if he's able to post.
Thank you. Defense?
Thank you, Your Honor. My client is not able to afford any money bail at this time. He has been working, just got a promotion, but is still having some difficulty in catching up with his financial obligations. One of his challenges in looking through his criminal history has been payment issues. He indicated that he had set some of those court obligations on an auto pay basis, but then changed banks and didn't update the payment or had missed updating the payment information, and so became behind on obligations that he had been trying to take care of. And then of course that, compounds into failures to comply. Pretrial was able to verify his information. He scores 1 point for residence, but that's because he's newly at that residence. He's been there for a couple of months. He's working construction and trying to, get on his feet to take care of obligations. As indicated in the probable cause, he was trying to uphold obligations for his child and maintaining visitation and all of those obligations as well. So he has struggled in the past. He is trying to turn that around, be more responsible, accountable, and handle his criminal obligations as well as his financial obligations. So we would ask the court to grant a known recognizance release with supervision as is deemed appropriate by the court and the supervising agency.
Thank you. Based on the facts as presented, the Nevada Pretrial Risk Assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note the history of non-compliance. Additionally, the likelihood of conviction as set forward in the probable cause declaration and the defendant's own statements with respect to the eluding charge. With that in mind, there's also the concern regarding the likelihood of appearance. With all of that in mind, the court is setting bail in the amount of $3,000 bondable with a 10% cash option. If the defendant is able to post that bail amount, I will require that he be supervised by pretrial services, as he would already be subjected to pretrial services in his pending case of with the Sparks Justice Court case. So that will be the order of the court. And we will set a 72-hour hearing, which will be set for December 5th at 9:30 a.m. Thank you.
Thank you, Your Honor.
Thank you, sir. Next, we have Lawrence McDavis, followed by Vernon Simon. Good morning.
Good morning, Your Honor.
We're here today for a first appearance bail hearing. Probable cause has been found for 2 separate matters, and the public defender's office has been appointed to represent you in each of those matters. The court is in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 5 or a moderate risk utilizing that tool. State, just to confirm, will this be filed in one case or should we file 2 separate judicial release orders?
I think it will be 2 separate cases, Your Honor.
Thank you. So I'll just note for the record that for the first case ending in 4-6, that is the one that is the resisting peace officer and battery and protected persons. And in the second matter ending in 4-7 is attempted burglary as a second resisting arrest and failure to register as required as a convicted person.
Thank you, Your Honor. So the state's requesting $5,000 bail on each case with DAS supervision if he's able to post. As Your Honor noted, he scores a 5 on the risk assessment. However, I think his criminal history is it's certainly more severe than scored. He has 6 prior felony convictions. 2015, he's got a felony conviction for burglary out of Las Vegas. 2014, he's got a felony arrest for home invasion out of Las Vegas with no disposition. He's got a gross misdemeanor conviction for conspiracy to commit burglary out of Las Vegas in 2014. He's got felony convictions for burglary and theft out of Utah in 2009, a felony conviction in 2009 for possession of a dangerous weapon out of Utah, and then a felony conviction for attempted burglary out of Las Vegas in 2008. He's got some earlier history in California and Utah as well, including a 2005 felony conviction for burglary out of Utah. So as we can see in both of these cases, he fled from officers. He doesn't have a documented criminal history since 2015, but his behavior in this case could explain the lack of recent documented criminal history. So the facts and circumstances of both cases lead to the conclusion that the defendant is a flight risk and he's a risk of continued criminal conduct. So the state is requesting bail in the amount of $5,000 on each case with DAS supervision if he's able to post.
Thank you. Defense?
Thank you, Your Honor. Mr. McDavis has shared with us this morning that he has been struggling with substance use disorder. And so that has been that was a factor in both of these charges, although not listed or charged. His desire is to really get himself into a rehabilitation program and to get his life back on track. The state noted he does have no criminal arrests within approximately the past 10 years, but he has started to struggle again. And so he has made some choices that have gotten him off of track, and he recognizes that. We were able to reach his wife this morning, who is supportive. She verified that he's been in the area for about 6 years and verified his phone number. So we would be requesting either an owner cognizance release with testing and supervision, and then Mr. McDavis can connect himself with a program, or if the court would be willing, that he go directly from the jail to a program so that he can avail himself of rehabilitation services, which are much needed in order for him to address his substance use disorder.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note the concerns regarding also the risk of flight as outlined in the declarations of probable cause sheets, the prior history involving felony convictions. I will note that that is a remote history involving those issues. Additionally, as noted, some lack of ties as addressed through the information with this community. Both of these judicial release orders, just for the record, will incorporate these findings of fact. With the release order ending in 4-6, the court will set bail in the amount of $3,000. That will be bondable with a 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by the Department of Alternative Sentencing, where so you must check in within 24 hours of release. I am also imposing the condition that you cannot possess any firearms or weapons, given that there was allegations that a firearm was, or not a firearm, that a weapon was involved. I do find that that is necessary in order to ensure the safety of the community. Additionally, the court will be setting as an additional condition that this judicial release order will read a bail or an own recognizance release through the Department of Alternative Sentencing or IAP or DSU to an appropriate treatment facility. I do find that that is a least restrictive means that can be imposed in order to ensure the safety of the community. In the case number ending in 47, I am imposing bail in the amount of $5,000 that will be bondable with no 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by the Department of Alternative Sentencing. I am also imposing the condition that he cannot possess any firearms or weapons given the allegations. I do find that that is fair and appropriate in this case. Additionally, I'm imposing the condition you are to have no contact with a location of 3095 Lakeside Drive. So you must stay 100 feet away from that location at all times. I am also imposing the additional condition that this will read that it is a bail or an own recognizance release through IAP, DAS, or DSU to an appropriate treatment facility. I do find that that is the least restrictive means that can be imposed in order to ensure the safety of the community. That will be the order of the court. And Madam Clerk, just to confirm, just for the record, that I am imposing DAS supervision in both of these matters in case I did not mention that. We will go ahead and set, thank you. We will go ahead and set a 72-hour hearing for both matters, which will be set for December 5th at 9:30 a.m. Thank you.
And contact with DAS in 24 hours when you're released.
Vernon Steinmans, followed by Mariah Wells. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8, which was overridden to a higher risk. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So Mr. Steinmans doesn't look like he has any criminal history since 2023. He's got a misdemeanor conviction for resisting, and in 2023 he was sentenced to do cap court in that case. However, he was removed from cap and his suspended sentence was revoked in July of last year. Looking at this case, I think it will likely be charged as a possession of drug paraphernalia. I'm not sure about that, but I think that's probably what will happen. And so the state's, maybe against my better judgment, I'm not objecting to an own recognizance release, DAS supervision with testing for controlled substances.
Thank you. Defense?
Your Honor, we would not object to that request.
Thank you, sir. I am going to grant your own recognizance release here today. You will be required to be supervised by the Department of Alternative Sentencing, so you must check in with the DAS within 24 hours of release. I am imposing the condition that you cannot use any controlled substances or alcohol or marijuana, and that you be subjected to random drug testing and alcohol testing. I do find that there is a sufficient nexus based off of the allegations as well as your criminal history. Additionally, I am requiring that you complete 3 mutual support groups per week. So those AA or those non-secular versions or NA is appropriate. And you will be required to provide proof of compliance to the Department of Alternative Sentencing. We will go ahead and set your arraignment, which will be set for December 18th at 9 a.m. So we'll see you back here in Reno Justice Court on that date and time. Thank you.
Yes.
Mariah Wells, followed by David Green.
Your Honor, Ms. Wells was not able to be transported to the courtroom this morning. I did speak with her and I'm prepared to go forward.
Thank you. We'll go ahead and waive her appearance for today's proceeding. We are here for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent her. I am in receipt of the Nevada pretrial risk assessment, which indicates that she scored as a 7, which was overridden to a higher risk. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So at first glance, I was thinking this would be an OR case. However, then I looked at her criminal history and she's got some issues there. So she has non-extraditable a non-extraditable warrant out of Idaho for a probation violation. Already this year, she's got a misdemeanor conviction for theft out of Iowa, with 90 days suspended. Also this year, she's got a misdemeanor conviction for assault while displaying a dangerous weapon out of Iowa. The disposition date on that case was November 6th of this year. So it was this month, with 240 days suspended in that case. 2024 misdemeanor arrest for resisting out of Colorado with a deferred sentence. She did report being on probation out of Colorado. That's the only case that I see out of Colorado, so I think it's probably that case. 2023, she's got a misdemeanor arrest for failure to appear ×2 out of Idaho. So she's got criminal history already out of 3 separate states in the last 2 years, with a non-extraditable warrant in one state and then a very recent conviction in another state with a suspended sentence. So unfortunately, she's a very high risk of continued criminal conduct. She also appears to be a risk of future non-appearance based on her failures to appear. It looks like out of several different states. So the state is requesting bail in the amount of $3,000 and DAS with testing if she's able to post.
Thank you. Defense?
Thank you, Your Honor. Ms. Wells does not have any financial resources to post money bail. She's been staying at a women's shelter that she was unsure of the name. It's located on 2nd Street. She is new to the area, has only been here for a couple of weeks. Based on her inability to afford bail, we would request an owner cognizance release with testing, given the charges involving a controlled substance.
Thank you. The court does find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So the defendant will be released here today on her own recognizance. I will require that she be supervised by the Department of Alternative Sentencing. So she must check in with the DAS within 24 hours of release. We will go ahead and set her arraignment, which will be set for December 18th at 9 a.m. Additionally, I am requiring that she appear in person in Reno Justice Court. It will be labeled as a review hearing. It is a mandatory appearance for the defendant. Madam Clerk, that will be set on my out of custody arraignment calendar, and that will be set for December 3rd at 9:30 a.m. I'm not going to impose testing at this time, given the charges and given the information. I do find that there are least restrictive means that can be imposed, and so that will be the order of the court, and we'll see the parties then. Thank you. David Green, followed by Justin Roper. Good morning. We're here today for a first appearance of bail hearing. Probable cause has been found and the public defender's office has not been appointed to represent you. Sir, do you wish to see if you qualify for the services of public defender here today?
Yes, please.
So, sir, assuming that you were to remain in custody, approximately how much money do you make per week?
Per week, probably
And
about,
that's assuming you're in custody. So are you able to make any amount while you're in custody?
no, ma'am, because I'm not, okay.
Thank you. I do find that you qualify for the services of public defenders. So the Washoe County Public Defender's Office will be appointed to represent you. I am in receipt of the Nevada Pretrial Risk Assessment, which indicates that you scored as a 7 or a moderate risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. The state's requesting bail in the amount of $5,000, DAS supervision if he's able to post, and no contact with Laura McClendon. So he scores a 7 on the risk assessment, but we didn't get the breakdown. Looks like he was ad booked. His other charge that he's in custody on, it's a domestic battery out of Sparks Municipal Court. That was an arrest from this year, so he's still being held on that, it looks like. He has a non-extraditable failure to appear warrant out of Iowa on a domestic assault case, and he's got a contempt warrant out of Colorado. 2017, he's got a felony arrest for failure to appear ×4, a felony conviction for attempted sex assault. In that case, he was sentenced to 96 to 240 months in prison. It looks like he had a supervision start date of June of this year. So I believe he's been in prison until June of this year, and now he's already in custody on 2 cases, including this one. 2015, he's got a misdemeanor arrest for violating a domestic violence TPO, 6 counts of that. I think it was out of Reno Municipal Court, and it was ultimately dismissed. And he has more criminal history in other states. But based on his risk of noncompliance, he's already not complying with the court order. He acknowledged he wasn't complying. Likelihood of conviction is very high. And also he's a risk of future non-appearance based on his existing failure to appear warrant out of Iowa on a separate domestic case. The state is requesting bail in the amount of $5,000, DAS supervision if he's able to post, and no contact with Laura McClendon.
Thank you. And state, can you confirm, is the first name Luara for the named
So
victim?
it's spelled two different ways in the PC sheet. I think the spelling is probably Laura.
Thank you. So what is your request for the no contact order, Laura?
Yes, Your Honor.
Thank you. And just to be sure that what I have for the last name is Mclengon. Is that correct?
I wrote down two. Oh, yes. No, that's correct, Your Honor. I spelled it wrong on my sheet.
Thank you, defense.
Thank you, Your Honor. As the court read the probable cause, Mr. Green is in on another case from Sparks Municipal Court, had misunderstanding about what was an option at the point that he was served, and but has no desire to contact the alleged victim, would absolutely abide by no contact orders. As indicated in the probable cause sheet, the content informed that he would be not contacting for future interaction, or would not have future interactions. We were able to speak to one of his references this morning to verify that he's been staying in the area since he paroled in June, that he's been working for a welding company, and verified his phone number. So as the state indicated, we don't have the precise breakdown for the MPRA score of 7 because this was an ad book, but he does have ties to the community and gainful employment, and has been supervised by the Division of Parole and Probation since his release. This is, again, an unfortunate incident. We clarified the process for a civil standby in order to resolve any lingering issues involving personal property. He will absolutely abide by the no contact order. He does not have any additional funds to post for bail. He's still being held on the Sparks Municipal case, having been not able to make that bail either. So in addition, he has had failures to appear in the past. In reviewing that, it does appear that they were some time ago. He recognizes that he was less likely to take responsibility during his prior court dates. The fact that he indicates that he was essentially, young and dumb, not appreciating the significance of failing to appear and handling those obligations. He's in a different position now and understands the significance and would comply with future court orders. Despite these charges, it's not indicative that he would thwart efforts at supervising him. So we would request a no recognizance release with any supervision conditions as imposed by the court, and he would abide by a no contact order with the alleged victim, as well as staying away from her residence, employment, and any other location where she would be known to be.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in order to ensure the safety of the community and the named victim in this case. Bail will be set in the amount of $3,000, bondable with a 10% cash option. Just for the record, that's based off the history of noncompliance, the allegations that's contained within this probable cause sheet, as well as I will just note the likelihood of conviction, just to make sure it's very clear of, in this case, I am imposing a no contact order. So you're to have no contact with the named victim in this case, and that begins immediately. The court is concerned regarding the statements that you made, indicating that I'm just going to give you a number to contact if you need to let me know anything. Just want to make sure that's very clear for this no contact order begins immediately, and that you must not contact and cannot attempt to contact the victim in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. That will be the order of the court. I will also require that if you are able to post that amount, that you are supervised by the Department of Alternative Sentencing. So you must check in with DAS within 24 hours of release. We will go ahead and set your 72-hour hearing, which will be set for December 5th at 9:30 a.m. Thank you.
Good, thank you.
Judge, is the no contact pursuant to statute or just this order?
Just this order. Thank you.
Thank you.
Justin Roper.
Your Honor, I think you might mean to call Robert Justin.
Thank you. Good morning. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 10 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. So he scores a 10 on the risk assessment. He's got a gross misdemeanor conviction this year for indecent exposure. He has 346 days suspended. It might be 364. Might be a typo. In any event, he's got a suspended sentence in that case. He's not on formal probation in that case, though. 2024, he's got a misdemeanor conviction for trespassing, another citation for trespassing, another conviction for trespassing. Looks like at least 3 convictions in 2024 for trespassing. He's got a gross misdemeanor arrest for indecent exposure in 2023. It looks like that case was dismissed, though. He did go through competency court in that case, and I think he was ultimately found competent. 2022 misdemeanor conviction for destruction of property and battery. 2021 a misdemeanor arrest for failure to appear. Misdemeanor conviction for harassment. 2020 misdemeanor convictions for DUI, petty larceny. He's got a felony conviction in 2018 for assault with a deadly weapon with force causing great bodily injury out of California. So he does have very recent criminal history, as I mentioned, that gross misdemeanor conviction this year for indecent exposure. And then he's got pretty significant criminal history between 2020 and 2024, including a felony conviction. So the state is requesting bail in the amount of $5,000, DAS supervision if he's able to post, and no contact with the victim.
Thank you. Just to confirm, do you want it the victim or the residence?
Actually, the residence is probably more appropriate, Your Honor, at 618 Robert Street.
Thank you. Defense?
Karen, we don't have any objection to the no contact with the residents. As indicated in the probable cause sheet, Mr. Justin was quite intoxicated with a blood alcohol level of 0.1, or excuse me, breath alcohol at 0.158, that he, again, quite intoxicated. He has been, is required to register and check in with local law enforcement based on his criminal history, and he's been doing that successfully. And he's been checking in, he reports monthly because he's had some instability in his address, and so wanted to make sure that he was fully compliant and following the directives for someone who's considered to be homeless with those very frequent check-ins. So he is someone who is able to follow requirements, maintain compliance, and abide by a court's order. With regard to some of the recent failures to appear, he indicated that he was given or not given a citation for the trespassing, told to that he was trespassed, and then didn't receive future court dates and has been struggling to resolve those issues in figuring out when and where he needs to be in order to resolve that. So again, he indicates that that was not due to trying to disobey the court's order, not comply with terms of supervision, rather something that he's been going back and forth for some time. We would ask for a known recognizance release with supervision, which he would be able to abide by. He does have local contacts and works as a carpenter, and so has some means to support himself.
Thank you. State, do you have any indication as to whether or not this would be charged as a felony for the battery on a protected person?
So Your Honor, when I was reading this, it kind of seems to me more like a battery on a protected person rather than a battery by a prisoner. I will likely be charging the gross.
Thank you. I appreciate that information. Just wanted to be clear for the record. So, sir, I do find that based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and your appearance. I will just note, based off the Nevada pretrial risk assessment, the criminal history of violence, the lack of ties to this community, as well as with the failure to appear, bail will be set in an amount of $4,000 that is bondable. I will permit a 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by the Department of Alternative Sentencing and must check in with DAS within 24 hours of release. I will go ahead and set a 72-hour hearing, and that will be set for December 5th at 9:30 a.m. Thank you.
Is Your Honor imposing the no contact with 618 Robert Street?
My apologies. Yes. So, sir, you to have no contact with that residence and must stay 100 feet away from 618 Robert Street. Thank you. And just to confirm, I believe that concludes all matters for today. Just wanted to double check before we log off.
It does, Your Honor.
Thank you, everyone. Have a great rest of your day.
Thank you, Your Honor. You too.